A. Clause 1 of the Act, if the employee number 1 is employed in any employment specified in Part A of the third schedule, or number 2 employed in any employment specified in Part B of the third schedule for a continuous period of not less than 6 months, or number 3 employed in any employment specified in Part C of the third schedule for such continuous period as specified by corporation in respect of such employment, contracts any digits specified there in the respective list are the occupational disease peculiar to that employment. The contracting of such disease shall, unless the contrary is proved, be deemed to be an employment injury arising out of and in the course of that employment. According to subsection 2, according to subsection 2, Clause I of this section 52A, the central government or state government, as the case may be, may add any description of employment to the employment specified in third schedule. Subsection 2, Clause 2 of this section empowers the corporation to, without prejudice to the power of the central or state government, to add to the schedule. According to subsection 3 and 4 of section 52A, neither this benefit shall be payable to an employee except as provided in subsection 1 and 2 of the section 52A, nor the provision of section 51A shall be applicable to cases in which 52A applies. What is the law relating to resignation, cessation and disqualification of membership of a member of the corporation, standing committee or the medical benefit council? Resignation. A member of the corporation, the standing committee or the medical benefit council may resign his office by notice in writing to the central government, and his seat shall fall vacant on the acceptance of resignation by that government. Section 11. Membership shall continue till the resignation is accepted in between the period of resignation and acceptance thereof. Any work done by the member will be deemed as valid. Cessation. A member of the corporation, the standing committee or the medical benefit council shall cease to be a member of that body if he fails to attend 3 consecutive meetings thereof. Provided that the corporation, the standing committee or the medical benefit council, as the case may be, may, subject to rules made by the central government in this behalf, restore him to membership. Where in the opinion of the central government any person nominated or elected to represent employees or the medical profession of the corporation, the standing committee or the medical benefit council, as the case may be, has ceased to represent such employees or the medical profession, the central government may, by notification in the official gazette, declare that with effect from such date as may be specified therein, such person shall cease to be a member of a corporation, the standing committee or the medical benefit council, as the case may be. Person referred to in clause 1 of section 4 shall cease to be a member of the corporation when he ceased to be a member of parliament. Section 12. Disqualification. A person shall be disqualified for being chosen as or for being a member of the corporation, the standing committee or the medical benefit council. A. If he is declared to be of unsound mind by a competent court, or B. if he is an undischarged insolvent, or C. if he has directly or indirectly by himself or by his partner any interest in a subsisting contract with or any work being done for the corporation except as a medical practitioner or as a shareholder, not being a director of a company, or D. it before or after the commencement of this act has been convicted of an offence involving moral turpitude. The term moral turpitude is a term of wide connotation, including such act and omission which the general society takes against the public interest and morality. Physical unfitness or incapacity is deemed as solid ground for disqualification. Example: paralysis, cancer, venereal disease. Once a member is found disqualified, he loses his right for reappointment. What are the purposes for which the fund of the employee state insurance may be expanded? Section 28 of the Act enumerates the purpose for which the fund of the Employee State Insurance Corporation may be applied. According to it, subject to the provision of this Act and of any rules made by the central government in that behalf, the Employees State Insurance Fund shall be expended only for the following purpose, namely: number 1, payment of benefits and provision of medical treatment and attendance to insured person, and where the medical benefit is extended to their families, the provision of such medical benefit to their families in accordance with the provision of the Act, and for defraying the charges and costs to connection therewith. Newly inserted Section 73A Clause A defines other beneficiaries, which means person other than the present insured, or other than the person insured under this act for the benefit of the beneficiary. The central government is empowered to frame a scheme from time to time under Section 73A Clause B. Number 2. Payment of fees and allowances to members of the corporation, the standing committee and the medical benefit council, the regional board, local committee, regional and local medical benefits council. Number 3. Payment of salaries, leave and joining time allowances, traveling and compensatory allowances, gratuities and compassionate allowances, pension, contribution to provident or other benefit fund of officers and servants of corporation, and meeting the expenditure in respect of offices and other services for the purpose of giving effect to the provision of this act. Number 4. Establishment and maintenance of hospital, dispensaries and other institutions, and the provision of medical and other ancillary services for the benefit of insured person, and where the medical benefit is extended to their families. Number 5. Payment of contributions to any state government, local authority or any private body or individual towards the cost of the medical treatment and attendance provided to insured person, and where the medical benefit is extended to their families, including the cost of any building and equipment in accordance with any agreement entered into by the corporation. Number 6. Defraying the cost, including all expenses of auditing the accounts of corporation and of valuation of its assets and liabilities. Number 7. Defraying the cost, including all expenses of the employees' insurance code set up under this act. Number 8. Payment of any sums under any contract entered into for the purpose of this act by the corporation or the standing committee or by any officer duly authorized by the corporation or standing committee in that behalf. Number 9. Payment of sum under any decree, order or award of any court or tribunal against the corporation or any of its officer or servants for any act done in execution of his duty or under a compromise or settlement of any suit or other legal proceeding or claim instituted or made against the corporation. Number 10. Defraying the cost and other charges of instituting or defending any civil or criminal proceeding arising out of any action taken under this act. Defraying expenditure with the limits prescribed on measures for improvement of the health and welfare of the insured person and for rehabilitation and re-employment of the insured person who has been disabled or injured, and such other purpose as may be authorized by the corporation with the previous approval of the central government. The medical hospital meant for the treatment of the injured and sick employees sometimes remain unutilized, which means not fully utilized by the person insured under this act. Section 73B, Clause D. Surcharges. Surcharges means the amount which is to be charged from the other beneficiaries for medical facilities as may be notified by corporation in consultation with the central government from time to time. The central government may by notification in the official gazette frame scheme for other beneficiary and to the members of their families for providing medical facilities in any hospital established by corporation in any area which is underutilized on payment of user charges, which shall be deemed to be the contribution and shall form part of the ES insurance fund. Section 73B and Section 73D reads like this: the scheme may provide for all or any of the following matters. The other beneficiaries who may be covered under this scheme. Number 2. Time and manner of availing of medical facilities. Number 3. Forms to be furnished by other beneficiaries. Number 4. Any other matter necessary or proper for the scheme. By amending Act of 2010, a new subsection 3 has been inserted in Section 59, which provides as under: the corporation may also enter into agreement with any local authority, local body or private body for commissioning and running employees insurance hospital through third party participation for providing medical in treatment and attendance to insured persons, and where such medical benefits has been extended to their families by the same amending Act of 2010. A new Section 59B has been inserted to empower the corporation to provide medical and paramedical education. For this, the corporation may establish Medical College, Nursing College, and Nursing Institute for its paramedical staff and other employees with a view to improve the quality of service provided under the Employee State Insurance Scheme. What is the law and procedure as to adjudication of dispute and claims arising out of or and under the Employees State Insurance Act 1948? Chapter 6 of the Act deals with the topic of adjudication of disputes and claims. The subject may briefly be discussed as follows. Constitution of Court, Section 74 lays down number 1. The state government shall by notification in the official gazette constitute an employees insurance court for such local area as may be specified in the notification. Number 2. Court shall consist of such number of judges as the state government may think fit. Number 3. Any person who is or has been a judicial officer or is a practitioner of 5 years standing shall be qualified to be a judge of the employees insurance court. Number 4. The state government may appoint the same court for 2 or more local areas or 2 or more courts for the same local area. Number 5. Where more than one court has been appointed of the same local area, the state government may by general or special order regulate the distribution of business between them. Matters to be decided by court. Number 1. If any question or dispute arises as to whether any person is an employee within the meaning of this act, or whether he is liable to pay the employee's contribution, or the rate of wages or average daily wages of an employee for the purpose of this act, or the rate of contribution payable by a principal employer in respect of any employee, or the person who is or was the principal employer in respect of any employee, or the right of any person to any benefit and to amounts and duration thereof, or any direction issued by corporation under section 55A on a review of any payment of dependents benefit, or any other matter which is in dispute between the principal employer and the corporation, or between the principal employer and an immediate employer, or between a person and the corporation, or between an employer and a principal or immediate employer in respect of any contribution of benefit or other dues payable or recoverable under this act, or any other matter required to be or which may be decided by the employees insurance court under this act, subject to the provision of subsection 2A of section 75. The following claims shall be decided by the employees insurance court, namely claim for recovery of the contributions from the principal employers, claim by a principal employer to recover contribution from any immediate employer, claim against a principal employer under section 68, claim under section 70 for the recovery of the value or amounts to the benefit received by a person when he is not lawfully entitled thereof, and any claim for recovery of any benefit admissible under this act. Matter mentioned in section 75 shall be adjudicated by the insurance court only, and in case by the civil court whose jurisdiction restricted in these matters. They cannot be raised in civil court. Ali Birla Jute Mills Company versus ESI Corporation 1962-20 FJR 495. It has been laid down by Supreme Court in the Employees State Insurance Corporation versus Central Press and another AIR 1977 SC 1351 that the corporation itself should be, in a case where there is omission on the part of the employer to maintain records in accordance with section 44, determine the amount of contribution on the strength of such information as it may collect, and can then make the demand under section 45A if the employer refuses to comply with the demand so made, and the matter so come up with before the employees insurance court under section 75. The court should give the corporation a direction to perform its duty where it considers that it should be performed by the corporation. It cannot decline to perform its own duty because the corporation has failed to discharge its function. Rule prescribing limitation for preferring claim is ultra vires of rule making power of the state government and is outside the purview of section 72 clause 2. The regional director employees state insurance corporation versus the assistant engineer municipal corporation 1912 lab IC 970. The question of liability and quantum being a matter of dispute between the corporation and the employer fully comes with the section 75 clause IG. Messrs. Paneshwar Mechanical Works Private Limited, Ludhiana versus Employees State Insurance Corporation, Amritsar, 1972. Lab IC 170. It has been held in ESI Corporation, Madras versus A. Jakaria, 1970. भेज दो तुम. That the Employees Insurance Court has jurisdiction to adjudicate and determine that amount which the disabled employee is entitled to get. It is competent to decide the period of such benefit. 2A. If any proceeding before the Employee Insurance Court, a disablement question arises, and the decision of a medical board or a medical appeal tribunal has not been obtained on the same, and the decision of such question is necessary for the determination of the claim or question before the Employees Insurance Court, that court shall direct the corporation to have the question decided by this act, and shall thereafter proceed with the determination of the claim or question before it in accordance with the decision of the medical board or the medical appeal tribunal, as the case may be, except where an appeal has been filed before the Employee Insurance Court under subsection 2 of section 54A, in which case the Employees Insurance Court may itself determine all the issues arising before it. Bar of Civil Court. No civil court shall have jurisdiction to decide or deal with any question or dispute aforesaid, or to adjudicate on any liability which by this act or under this act is to be decided by medical board or by medical appeal tribunal or by the Employee State Insurance Court, if the employer is aggrieved with the order of making the contribution. The best course open to him is to take recourse to the Employee State Insurance Court, where he can seek remedy. New section 45 AA inserted by amending Act 2010 provides if the employer is not satisfied with the order referred to in section 45A, he may prefer an appeal to an appellate authority, as may be provided by regulation within 60 days of date of such order, after disposing 25% of the contribution as per his own calculation, whichever is higher with the corporation. In order for contribution, if the order for contribution is not acceptable to the employer, the corporation should refer the matter to the insurance court and not the civil court. The claim must be made in insurance court only. A decision to this effect is delivered by the Kerala High Court in Regional Director ESI Corporation Trichur versus Maricar Engineering Limited, 1982. बात मत करो अभी, हम लाइव में है ना. Institution of proceeding. Subject to the provision of this act, any rule made by state government, all proceeding before the Employees Insurance Court should be instituted in the court appointed for the local area in which an insured person was working at the time the question on dispute arose. Number 2. If the court is satisfied that any matter arising out of any proceeding pending before it can be more conveniently dealt with by other Employees Insurance Court in the same state, it may subject to any rules made by state government in this behalf, order such matter to be transferred to such other court for disposal, and shall forthwith transmit to such other court the records connected with that matter. Number 3. The state government may transfer any matter pending before an Employees Insurance Court in the state to any such court in another state with the consent of the government of that state. Transfer can be made by government suo motu or on the motion of the Employees Insurance Court. Number 4. The court to which any matter is transferred under subsection 2 or subsection 3 shall continue the proceeding as if they had been originally instituted in it. Commencement of proceeding. Number 1. The proceeding before an Employee Insurance Court should be commenced by application. Application can be made within 3 years from the date on which the cause of action arose. Every such application shall be made within a period of 3 years from the date on which the cause of action arose. The actual happening of the accident must be clearly shown and proved. It is deemed proved when the employer does not challenge the fact of accident mentioned in the application. Explanation. For the purpose in this subsection, number A, the cause of action in respect of a claim for benefits shall not be deemed to arise unless the insured person, or in the case of a dependent benefit, the dependent of the insured person claims or claim that benefit in accordance with the regulation made in that behalf within a period of 12 months or after claim become due or within such period for the period as the employee's insurance court may allow on grounds which appear to it to be reasonable. In case of delay, the applicant has to prove that there was reasonable and sufficient grounds of not presenting the claim within the prescribed period of 12 months. It is the satisfaction of the court that is material in this respect. Being satisfied with the assigned reason of delay, the court can entertain the claim and claim shall be treated as valid and legal made in time. Number B. The cause of action in respect of a claim by the corporation for recovering contribution from the principal employer or a claim by the principal employer for recovering contribution from an immediate employer shall not be deemed to arise till the date by which the evidence of contributions have having been paid in is due to be received by the corporation under the regulation. Number 2. Every such application shall be in such form and shall contain such particulars and shall be accompanied by such fee, if any, as may be prescribed by rules made by state government in consultation with the corporation. In Regional Director Government of India versus VG Iyer 1972 Lab IC 784, the court has observed that Section 77 IA of the Employees State Insurance Act, which was inserted by Act 44 of 1966 and came into force on 20th January 1968, could have no effect on application made under Section 75 earlier to that date. Power of the Employees Insurance Court. Number 1. The Employees Insurance Court shall have all the powers of a civil court for the purpose of summoning and enforcing the attendance of witnesses, compelling and the discovery and production of documents and material objects, administrating oath and recording evidence, and such court shall be deemed to be a civil court within the meaning of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. This was inserted by Amendment Act 1984. Number 2. The Employees Insurance Court shall follow such procedure as may be prescribed by rules made by the state government. Since insurance court has some of the powers of the civil court, hence it has to act and proceed like a civil court and execute its decision accordingly. All costs incidental to any proceeding before an employee insurance court shall subject to such rules as may be made in this behalf by the state government, be in the discretion of the court. Number 4. An order of the Employees Insurance Court shall be enforceable as it were a decree passed in a suit by a civil court. If the insurance court finds that any substantial question of law is involved in any matter before him for consideration, he may refer the same to the High Court for clarification. It is getting the clarification from the High Court, the insurance court shall proceed in the light of the same. Appearance by legal practitioner, etc. Any application appearance of act required to be made or done by any person to or before an employee's insurance court other than appearance of a person required for the purpose of his examination as a witness may be made or done by a legal practitioner or by an officer of a registered trade union authorized in writing by such person or with the permission of the court by any other person so authorized. Reference to High Court. Any employee insurance court may submit any question of law for the decision of High Court. Employee insurance court may submit any question of law for the decision of High Court. For the decision of whom? For the decision of High Court. On reference will communication its decision to the insurance court. On reference will communicate its decision to the insurance court. If it does so, it shall decide the question pending before it in accordance with such decision. If it does so, it shall decide the question pending before it in accordance with such decision. Appeal. Number 1. Save as expressly provided below. No appeal shall lie from an order of Employees Insurance Court. No appeal shall lie from an order of Employees Insurance Court. Number 2. An appeal shall lie to the High Court from an order of Employee Insurance Court if it involves a substantial question of law An appeal shall lie to the High Court from an order of an employees insurance court if it involves a substantial question of law. An appeal lie only against a final order but also against interlocutory orders. An appeal lie not only against a final order but also against interlocutory order. 1961 MPLJ 550. The decision of the Employees Insurance Court is binding on both the party. The decision of the Employee Insurance Court is binding on both the parties. Any party feeling aggrieved by the decision may prefer an appeal when some prescribed conditions are fulfilled. Then only the party may go to appeal. Any party aggrieved by the decision may prefer an appeal when some prescribed conditions are fulfilled. The High Court will entertain the appeal only when it is fully satisfied that a real substantial question of law is involved. High Court will entertain the appeal only when it is fully satisfied that a real substantial question of law is involved. The decision in appeal shall prevail over the decision of the insurance court, which will execute it accordingly. The decision in appeal shall prevail over the decision of the insurance court, which will execute it accordingly. Period of limitation for such appeal shall be 60 days. Period of limitation for such appeal shall be 60 days. The provisions of Section 5 and 12 of the Indian Limitation Act shall apply to such appeals also. The provision of Section 5 and 12 of the Indian Limitation Act shall apply to such appeals also. Appeal cannot be preferred by way of right. It can be made only when some substantial question of law is involved. Appeal cannot be preferred by way of right. It can be made only when some substantial question of law is involved. If there is only pure question of law, the High Court will not entertain the appeal. If there is only pure question of law, the High Court will not entertain the appeal. ESI Corporation Madras vs. Jakaria 1972 LL 96. Questions relating to interpretation of words as who is employee, which machinery is dangerous, and similar other matters involve question of law for the purpose of appeal. Questions relating to interpretation of words as to who is employee, which machinery is dangerous, similar other matters involve question of law for the purpose of appeal. JB Mangaram versus Company, Mangaram and Company versus ESI Corporation, AIR 1960, MP 110. Question of law is to be interpreted by the High Court. Any decision on that point will be binding on the Employees Insurance Court and other courts as well till that decision is changed or overruled. Question of law is to be explained by High Court. Any decision on that point will be binding on the Employees Insurance Court. Another court will as well till that decision is changed or overruled. The Act further provides that where the corporation has presented an appeal against an order of the Employees Insurance Court, the court may, if so directed by the High Court, shall, pending the decision of the appeal, withhold the payment of such sum directed to be paid by the order appealed against. The Act further provides that where the corporation has presented an appeal against the order of an insurance court, employee insurance court, the court may, if so directed by the High Court, shall, pending the decision of the appeal, withhold the payment of any such sum directed to be paid by the order appealed against. Insurance court is bound to comply with such order. Insurance court is bound to comply with such order. Non-compliance of such orders shall be treated as contempt of court. Appeal to Supreme Court. In the rarest of the rare case, the Supreme Court will grant special leave for filing an appeal in the Supreme Court from any judgment, decree, sentence or order of the High Courts. In the rarest of the rare case, the Supreme Court will grant special leave for filing an appeal in the Supreme Court. Supreme Court will grant special leave for filing an appeal in the Supreme Court from any judgment, decree or sentence or order of the High Court. This caution is given by Supreme Court with a view to minimize and hold the litigious mentality of the public corporation. ESI Corporation vs. Amir Hassan 1981 LLJ 164. No appeal can be preferred to Supreme Court when the order is purely executive or administrative. It shall be a judicial or quasi-judicial character. No appeal can be preferred in Supreme Court when the order is purely executive or administrative. It shall be of a judicial or quasi-judicial character. Bar to the jurisdiction of civil court. No civil court has jurisdiction to decide or deal with any question or dispute as referred to in section 75, clause 3 of the Act, or to adjudicate on any liability which by the said Act or under the said Act is to be decided by the Employees Insurance Court. Bar to jurisdiction of civil court. No civil court has jurisdiction to decide or deal with any question or dispute as referred to in 75 clause 3 of the Act, or to adjudicate on any liability which by or under the said Act is to be decided by the Employees Insurance Court. What do you understand by contribution? Describe the general provision for their payments. Contribution means the sum of money payable to the corporation by the principal employer in respect of an employee and includes any amount payable by the employee or on behalf of the employee in accordance with the provision of this Act. Contribution means sum of money payable by the corporation by the principal employer in respect of an employee and includes any amount payable by the employee or on behalf of the employee in accordance with the provision of this Act. Contribution payable by an employer shall comprise contributions payable by the employer. Contribution payable by employer shall comprise of contribution payable by employer known as employer's contribution and the contribution payable by the employee known as employee's contribution shall be paid to the corporation. Contribution payable by the employer shall comprise of contribution payable by the employer and the contribution payable by the employee shall be paid to the corporation. So both employer and employee contribution shall be paid by the employer. It is the legal duty of the employer to collect the employee's share of contribution and then pay the amount along with his own share of contribution. It is the legal duty of the employer to collect the employee's share of contribution and then pay the amount along with his own share of contribution. The contribution shall be paid at the rates specified in the first schedule, and in cases where the provision of this Act are made applicable to any employee or class of employee in any factory or establishment or class of factories or establishment in such a manner that they are excluded from some of the benefits under this Act, or such rate as the corporation may fix in this behalf. A week shall be the unit in respect of which all contributions shall be payable under this Act. The contribution payable in respect of each week shall ordinarily fall due to the last day of the week, and where an employee is employed for part of the week or is employed under two or more employers during the same week, the contribution shall fall due on such day as may be specified in the regulation section 59. But no such order shall be passed by the corporation in respect of the period beyond 5 years from the date on which the contribution shall become payable. The principal employer shall pay in respect of every employee, whether directly employed by him or by the immediate employer or through the immediate employer, both employers and employees' contribution for each week during the whole or any part of which an employee is employed. No contribution shall be payable in respect of an employee whose average daily wages are below 50 rupees. No contribution shall be payable in respect of an employee whose average daily wages are below 50 rupees. This exemption is provided taking into the meager amount of low paid wages. Taking into view the meager amount of low paid wages. Contribution means the sum of money payable to the corporation by the principal employer in respect of an employee and includes any amount payable by the employee and on behalf of the employee in accordance with the provision of this Act. The contribution payable by an employer shall consist of contribution payable by the employer and contribution payable by the employee. shall be paid to the corporation. It is the legal duty of the employer to collect the employee's share of contribution and then pay the amount along with their own share of contribution. The contribution shall be paid at the rates specified in the first schedule, and in cases where the provision of this act are made applicable to any employee or class of employee in any factory or establishment or class of factories or establishment in such a manner that they are excluded from some of the benefits under this act at such rate as the corporation may fix in this behalf. A week shall be the unit in respect of which all contributions shall be payable under this act. A week shall be the unit. The contribution payable in respect of each week shall ordinarily fall due on the last date of the week, where an employee is employed for part of the week or is employed under two or more employers during the same week. The contribution shall fall due on such day as may be specified in the regulation. Section 39. But no such order shall be passed by the corporation in respect of the period beyond 5 years from the date on which the contribution shall become payable. Principal employers shall pay in respect of every employee, whether directly employed by him or by the immediate employer or through the immediate employer, both the employer's and employee's contribution for each week during the whole or any part of which an employee is employed. No contribution shall be payable in respect of an employee whose average daily wages are below 50 rupees. This exemption is provided taking into view the meager amount of low paid wages. Such payment and recovery of paid contribution depend on the terms and conditions agreed upon between the principal employer and the immediate employer. But after the payment of the contribution of employee, he has every right to be reimbursed by the immediate employer. The average daily wages of an employee shall be calculated in the manner specified in the first schedule. The average daily wages of the employee shall be calculated in the manner specified in the first schedule. Where the wages of an employee are for a portion of a week, the employer shall pay the employee's contribution in full. Where an employee did not work for the whole week or no wages were due to him, no contribution shall be payable in respect of him. However, contributions shall be payable in respect of any week during which no services are rendered, low and no wages are paid to an employee at the rate which contributions was last paid. Where the failure to render such services due to the employee being an authorized leave or is due to a lockout or a legal strike, if in respect of the period covered by such legal strike the employee received the wages in full or in part, the principal employer who has paid contribution in respect of an employee employed by an immediate employer or through an immediate employer is entitled to recover the amount of contribution so paid from the immediate employer, either by deduction from any amount payable to him by the principal employer under any contract or as debt payable by the immediate employer. It is the primary liability of the employer under the section to pay both the employer's and employee's contribution in the first instance. Employer cannot contend that as he had not deducted the employee's contribution from the wages of the employees, he could not be made liable for their contribution, nor can he contend that he may not find it possible to recover the contribution from the employees in terms of the act. Inderpuri Studio Private Limited versus Employees State Insurance Corporation 1961 to 62 20 EJR 365. Any amount payable as contribution can be recovered as land revenue. It was being held in Royal Talkies, Hyderabad versus ESI Corporation AIR 1978 SC 1478 that the Talkies owner will have to pay contribution for all those workers who are engaged in incidental work, that is, contribution for person engaged in canteen, car parking, cycle stand and lavatories, inspection of record, etc. Any officer of the corporation authorized in this behalf by it may carry out reinspection on or test The inspection of the records and returns submitted for the purpose of certifying the correctness and quality of the inspection carried on by the Social Security officers, formerly inspectors. Section 43 makes provision for the method of payment of contribution. It was held by the Punjab High Court that the chairman and directors of the company, not having ultimate control, are not principal employers, and so they are not liable to pay arrears of contribution. Section 43 makes provision for method of payment of contributions. It was held by Punjab High Court that the chairman and directors of a company, not having ultimate control, are not principal employers, so they are not liable to pay arrears of contribution. S. Gurdail Singh versus Regional Director Employee State Insurance Corporation, AIR 1974. A new section 45AA has been inserted by ES Insurance Amendment Act 2010, which provides if employer is not satisfied with the order. If the employer is not satisfied with the order referred to in section 45A, so what was 45A? 45A, we have discussed 45A. If the employer is not satisfied with the order referred to in section 45A, he may prefer an appeal to an appellate authority, as may be provided by regulation. Within 60 days from the date of such order, after depositing 25% of the contribution so ordered, or the contribution as per his own calculation, whichever is higher with the corporation. Provided that if the employer finally succeeds in the appeal, the corporation shall refund such deposit to the employer together with such interest as may be specified in the regulation. The method of constitution of appellate authority and the rate of interest on an amount deposited by the employer with the corporation shall be prescribed. Define the permanent partial disablement, permanent total disablement. Permanent partial disablement means such disablement of permanent nature as reduces the earning capacity of an employee in every employment which he was capable of undertaking at the time of accident, resulting in the disablement, provided that every injury specified in Part 2 of the second schedule shall be deemed to result in permanent partial disablement. Permanent total disablement.